Today is November the 15th, 2012. We're present in Nashville, Tennessee for a hearing before the Tennessee Alarm System Contracting Board. The board will consider the case of the state versus C&Com, is that CINCOM? Is that what we call it? Inc., doing business as American Digital Monitoring, docket number 12.34-115034A. I'm Joyce Staffley, and I'm the administrative judge who's been assigned by the Secretary of State to preside at a hearing of this matter. During the hearing, I'll make all rulings regarding evidentiary matters, admissibility of evidence, those types of procedural things. The board will make the ultimate decision in the case. I will not participate in any findings of fact or in any decision made by the board. At this time, I'll ask the board members to introduce themselves for the record, starting with Mr. Tucker, please.
Steve Tucker, West Tennessee.
Karen Jones, East Tennessee. Vivian Hickson, East Tennessee.
Ken Roberts, Middle Tennessee.
Keith Harvey, West Tennessee.
Is there a quorum of the board, Chairperson Hickson?
Yes,
All right, at this time, council, if you'll state your appearance for the record and indicate if you have a party representative with you.
Yes, this is Jesse Joseph, Assistant General Counsel from the Department of Commerce and Insurance. And yes, Your Honor, we have our party representative, the Executive Director.
I'm David Riley of the National Bar, and we are the respondent today.
All right, members of the board, as you know, there are certain charges I'm required to give you before the case begins, so we're going to start with the charges. You're reminded that during the time this hearing is being conducted, no discussion concerning the case should take place between board members and the judge, witnesses, attorneys, other board members, or other persons unless all parties are present. During the hearing, this board sits as a jury and must only consider the evidence introduced at the hearing in reaching its decision. The Tennessee Sunshine Law or Open Meetings Act requires that all board discussions and deliberations be in public for all parties. Failure to observe the Sunshine Law will likely result in the board's action being reversed or remanded if this matter is appealed to Chancery Court. Board members, you are reminded that the law requires you to disclose on the record any outside knowledge of this case or any communications, whether written, verbal, or otherwise, from any parties concerning the case. Members of the board, do any of you have any outside knowledge of this case? All right, let the record reflect. They've all replied negatively. Okay, as I stated before the case begins, I'm required to give you some instructions regarding helping you to understand how the case will proceed, what your duties will be, and what your conduct will be during the hearing. And I know this is an experienced board, and y'all told me y'all had lots of hearings, so I'll skim over that if I need to. When I have completed my instructions, the attorneys will make opening statements in the case, and after the opening statements, then the board will hear the evidence. The state has the burden of proof in this matter, so the state will present its evidence first, and the respondent will then be given an opportunity to present any evidence. During the course of the hearing, there will be an opportunity for each of you board members to question the witnesses regarding testimony that's been taken under oath. You may use your questions to gain information which you feel would assist you in reaching your decision in this case. You should reserve any expression of any opinions you may have on the facts until the portion of the hearing which is set aside for the board's deliberations after all the proof in the matter has been heard. During the hearing, objections may be made to evidence or certain procedures. I may sustain the objections to questions asked without permitting a witness to answer, or I may instruct the board to disregard an answer that has been given. In deciding your case, you are not to draw any inference from any unanswered question, and you may not consider testimony which you have been instructed to disregard. Any arguments about objections or motions, evidentiary motions, are usually done outside the hearing of the board. So, especially if they're going to be lengthy. So, information may be excluded because it's not legally admissible. Excluded information cannot be considered in reaching your decision. A ruling that is made on an objection or motion will be based solely upon the law, and you must not infer from any of my rulings that I hold any opinion or view for or against either party in this case. When all the evidence has been presented to you, the attorneys will make closing arguments. The attorneys will point out to you what they contend the evidence has shown, what inferences you should draw from the evidence, and what conclusions you should reach. The state will make a closing argument first, followed by the respondent's closing argument. Statements by the attorneys are not evidence. Attorney statements are made only to help you understand the evidence and apply the law to the evidence in this case. You should ignore any statement by counsel that is not supported by the evidence. After the closing arguments are made, I will instruct the members of the board on the rules of law that apply to this case. It is your function, members of the board, to determine what the facts are, to apply the rules of law that I give you to those facts, and to make conclusions of law in which you decide whether or not certain rules and or statutes have been violated, and if such violations have occurred, what the proper discipline is which should be taken against the respondent. The board will also then need to state a policy reason for the discipline imposed, if any. In deciding what evidence you will accept, you must make your own evaluation of the testimony given by each of the witnesses and determine the weight that you will give to that testimony. You are not required to accept or reject anything or everything a witness says. You're free to believe all, none, or part of any person's testimony. In deciding which testimony you believe, board members, you may rely upon your own common sense and experience. Counsel, are there any stipulations by the parties?
No.
No stipulations?
No stipulations.
Well,
but
don't make it easy for me, counsel.
There
All
are,
right.
there are some admitted facts though, but per the request for.
All right. Any announcements? Any other preliminary matters?
No other preliminary matters.
All right. All right, and I'm assuming you do or do not want the rule?
Please.
You do want the rule. All right, Mr. Briley has asked for the sequestration rule, which means that any witness who is to be called to testify may not remain in the room. The parties may not communicate to the witnesses what prior testimony has been. The witnesses may not communicate to other witnesses what prior testimony has been, and you must leave the room. So, at this time, Mr. Joseph, you know who your witnesses are, so you need to ask them to leave the room and
Yes, until they're called.
until they're called. That's right. All right, do members of the board have the copies of applicable statutes and rules before them? And do members of the board have the notice of hearing before them? Yes?
I haven't disseminated a notice of
Would you
hearing
like
charges.
to-
Yeah, I was waiting on your honor's approval.
All right, now would be a good time.
All right.
If you want to get published, the notice of hearing to the board members, now would be a great time.
Oh.
All right, and for purposes of the record, I need to state what the technical record is at this time. If the board just wants to be reading the notice of charges or the notice of hearing while I do that. The technical record at this time consists of the following documents. The state's notice of hearing and charges, which was filed on April the 3rd, 2012. A motion to continue the hearing, which was filed on July the 17th, 2012. An order of continuance entered by Judge Summers. A pre-hearing order entered by Judge Summers. A state's list of proposed witnesses and exhibits. A pre-hearing order which I entered. September the 25th, 2012. State's motion to deem admitted matters regarding which admissions were requested. Respondent's response to motion to deem admitted. State's amended list of proposed witnesses and exhibits, and the state's reply and withdrawal of motion to deem admitted. Counsel, is that the technical records you understand at this time?
There should be one order, Your Honor. You may have mentioned it, but there should have been a continuance order that was entered by the Honorable Judge Joyce Carter Ball in that file as well. I don't know if Your Honor mentioned that.
Sometimes in July. Yeah, that was the third one.
I've got an order of continuance from Judge Summers and 17th of May, and you're absolutely correct. There is an order of continuance entered by Judge Carter Ball on July the 25th, 2012. So with that correction, as counsel understands it, is that the technical record at this time?
Sounds completely right.
All right, it'll be entered. All right, the party's ready to proceed.
Yes, Your Honor.
All right, opening statement, Mr. Joseph.
Thank you. Good afternoon, members of the board. This is a notice of hearing and charges that the state's filed against the respondent, CENTCOM Incorporated, doing business as American Digital Monitoring, a company located in the state of Washington. The respondent has never been certified as an alarm systems contractor by this board. The state's proof will show in this matter that at some point in 2001, the complainant in this matter, Ronnie Pollard, who is the owner and designated qualifying agent of Mid-South Security and Intercoms, located in Olive Branch, Mississippi, was contacted by a representative of the respondent company who informed the complainant that the respondent was able to perform alarm systems contracting work in Tennessee. Mid-South Security and Intercoms is a company certified as an alarm systems contractor in Tennessee and licensed as an alarm systems contractor in the state of Mississippi. You will hear from Mr. Pollard today, who will testify, and the proof will show that the respondent's representative indicated to Mr. Pollard that the respondent was certified to do alarm systems contracting work in Tennessee. Mr. Pollard took the respondent at its word in 2001, checked the respondent's website at that time, which indicated that Tennessee licensing was in process. Mr. Pollard agreed to do business with the respondent in November of 2001 at the agreed rate he had reached orally by phone with the respondent, and will admit that he did not check with this board staff as to whether or not the respondent was certified as an alarm systems contractor in Tennessee. The state's proof will also show further that Mr. Pollard did business with the respondent, allowing the respondent to monitor all of his company's Tennessee and Mississippi client accounts. Under this oral arrangement until February 12th of 2010, when Mr. Pollard signed a document called a wholesale monitoring agreement, which was prepared by the respondent. The proof will also show that Mr. Pollard continued to do business with the respondent until approximately July of 2010, when Mr. Pollard terminated his business arrangement with the respondent due to some billing disputes, and after learning from Ronald Katz, the respondent's owner, that the respondent was not certified as an alarm systems contractor in Tennessee, given Mr. Katz's assertion that the respondent was not required to be so certified in Tennessee. It will be shown that the respondent then filed a lawsuit against Mr. Pollard, his wife, and Mid-South Security and Intercoms in September of 2010 in the King County, Washington Superior Court for breach of contract, seeking over $217,000 in damages. The chronology continued with the respondent proposing a settlement agreement to Mr. Pollard in November of 2010, which would have required Mr. Pollard's company to again allow respondent to continue monitoring Mr. Pollard's Tennessee client accounts, and which would also have required Mr. Pollard to assist the respondent in obtaining a Tennessee license. Mr. Pollard did not sign this proposal that was tendered to him in November of 2010, and ultimately the Washington State Court lawsuit was dismissed. The state will also put on proof demonstrating that Mr. Pollard filed a complaint with this board staff in January of 2011 against the respondent alleging unlicensed conduct that month, that the respondent was sent a copy of this complaint and received it but never submitted any response to the board staff. Moreover, the state has downloaded and printed off publicly available copies of the respondent's website on March 14, 2011, approximately 2 months after the complaint was filed. Again, on April the 2nd, 2012, 1 day before the notice of hearing and charges was filed in this matter. And on October the 2nd, 2012, 5 weeks ago, and on all 3 of these copies of the respondent's website, the respondent has continued to hold itself out as engaging in the business of an alarm systems contractor in Tennessee by advertising nationwide monitoring and by claiming a state licensing number in Tennessee of quote-unquote NA 3600328, and a further explanation to the effect that NA indicates licensing in process or not required. From the state's perspective, both of these assertions are false as a matter of law. Certification to act as an alarm systems contractor has been required in Tennessee by statute since 1991, and through the filing of the notice of hearing and charges in this matter on April the 3rd, 2012, the respondent had submitted no application to become certified as an alarm systems contractor in this state. The proof will also show that after the filing of the notice of hearing and charges in this matter on April 3rd, 2012, the respondent did submit an application to become certified with this board on July the 12th, 2012. That application is still in process. However, the state submits that even after the respondent filed its application on July 12, 2012, the claim that licensing was in process is nonetheless misleading to the general public, because every entity that applies for a license or certificate will not necessarily be granted the license or certificate. It is clear, based upon provisions of Tennessee Code Annotated, that the monitoring of alarm systems in Tennessee is within the definition of an alarm systems contractor pursuant to TCA 6232.303 subsection 2, and section 6232.304A sets forth that no person shall engage in or hold out as engaging in the business of an alarm systems contractor without first being certified in accordance with this part. Based on the entirety of the proof which will be presented to the board today, the state would request that the board conclude that the respondent engaged in unlicensed conduct in Tennessee and has violated the provisions cited by the state in the notice of hearing and charges, and that the respondent should be assessed a civil penalty in the first major category of $1,000 per month for 8.5 years of continuously monitoring Mr. Pollard's Tennessee client accounts from November of 2001 through July of 2010, 103 months, without ever being certified by this board in violation of TCA 6232.304J, treating each month of unlicensed conduct as a separate violation for a total civil penalty within this category of $103,000. The state would also request that a second category of violations be found by the board, and that the board assess a separate civil penalty against the respondent of $1,000 per month for 20 months from March of 2011, the first month that the state obtained a copy of the respondent's website, through October 2012, which is the last month the state obtained a copy of the respondent's website, due to the respondent's holding itself out on that website as engaging in the business of an alarm contractor in Tennessee in violation of TCA 6232.304A, and by referencing a Tennessee state licensing number, and by making what we contend are 2 false statements. The first being that licensing is not required in Tennessee, and the second being that licensing is in process. As the state has indicated before, the respondent's claim that licensing is in process impliedly assumes that it will obtain a license. merely by filing an application, which is never the case. Finally, the state would request the board in a third category of violations to assess a civil penalty of $100 per month for the more than 10.5-month period of time from November of 2001 through July of 2012, which is 128 months, for failing to submit an application for certification to this board as required by the rules that are cited in the notice of hearing and charges. July of 2001 is the first month in which, November of 2001 is the first month in which the respondent began to monitor Mr. Pollard's Tennessee accounts and hold itself out as an alarm systems contractor in Tennessee. And July 12th of 2012 is when the respondent's application for certification was received by the board staff. To recapitulate, the state would request in this matter that the board assess a total civil penalty of $103,000 for the first category, $20,000 for the second category, and $12,800 for the third category, for a total assessed civil penalty of $135,800. Finally, after hearing the entirety of the proof in this matter, the state would respectfully request that this board assess the cost of this clause, including the cost of the Administrative Procedures Division and the cost of the court reporter incurred herein against the respondent, CENTCOM Incorporated. Thank you.
Mr. Briley?
Thank you. Well, initially, I'd like to say thank you to the board for your service to the state, and I know that it takes time out of your days, and on my behalf as a citizen here, I'd like to say thank you, and on behalf of my client, I'd like to say thank you for taking time to hear this dispute. One thing that the judge said at the outset was that there might be evidentiary rulings, there might be things that come in, things that don't come in, and that you can only consider those matters that the judge actually allows to come before you. So I'd like to start by asking that you withhold judgment until you have the proof in front of you and see what actually is there. It's my sense that many of the things that were just represented will actually not be more than just statements of counsel. Beyond that, I think that the law is clear that there has been no violation, period. And I'll make that clear as we go through why there's not been a violation in the state of Tennessee. Further, I think at the end of the day, you'll see that even if the board finds that there was a violation, that there's been no harm. And the regulations governing this board's conduct today and the imposition of the civil penalty requires the board to consider the harm. And there will be no proof of any harm. And for the state to ask for $138,000, $135,800 without any proof of any harm to anybody, it's just not justified. So I hope you'll keep an open mind, wait to see what comes before you, and then listen to the argument. Thank you.
All right, Mr. Jessup, like the first witness.
Your Honor, before I call my first witness, I wanted to ask Mr. Briley and ask Your Honor, I would like to introduce as the state's first exhibit. Your Honor, we'd like to enter into evidence a copy of a corporation's detail regarding the respondent CENTCOM, which was printed from a publicly available Secretary of State's website in the state of Washington, which recites the incorporation status of the respondent, when it was incorporated, who the registered agent is, and the filing date of the corporation and the expiration date, none of which we understand to be contested in this case. And furthermore, within a copy of the respondent's application for certification, the respondent admits the same information and also provides copies of the certificate from the state of Washington. And we don't see why this is objectionable, and we would ask that this be allowed to proceed.
All right, your objection, Mr. Briley?
I think we're going to have this objection a lot today. It's hearsay. Anything printed from a publicly available website is simply hearsay it's not in any exception to the hearsay rule. So, I mean, it's a statement, an out-of-court statement presented to prove the matter asserted, and it doesn't fall within any exception to the hearsay rule.
I think that the matter, quite frankly, Your Honor, is such that the court could, for all practical purposes, take judicial notice of it. This is printed from a publicly available website of the state of Washington. It's not subject to reasonable dispute. And the respondent has admitted the substance of this within his own application for certification.
May I see it, please?
Yes.
Your Honor, if I could add one thing.
Yes, sir.
Setting aside whether or not it's hearsay, because it's clearly hearsay, it's not authenticated except through Mr. Joseph's testimony. The only way that we know that that came from a website is from what he is saying right now. There's no testimony in front of this body that would give any indication that is. And so if he wants to be a witness here to say I printed that from their website, I think he can do that if he'd like, but it's going to be hard for him. He can't then be the attorney representing the agency.
All right. The rule that would govern this would be Rule 803, parenthesis A, public records and reports, which states unless the source of information or the method or circumstances of preparation indicate a lack of trustworthiness, records, reports, statements, or data compilations in any form of public offices or agencies, setting forth the activities of the office or agency or matters observed pursuant to a duty imposed by law, that there's a duty to report, may be admitted as an exception to the hearsay rule. However, in this particular document, it states at the very top of the document, neither the state of Washington nor any agency, officer, or employee of the state of Washington warrants the accuracy, reliability, or timeliness of any information in the public access system. And it also goes on to say, while every effort is made to ensure the accuracy of this information, portions may be incorrect or not correct. For that reason, I believe that it isn't
Your Honor, could I proffer? I understand where Your Honor is going with that.
well, I'm
Could we
getting ready
just-
to exclude it. If you want to make a proper...
I want to make a proffer that we withhold the ruling on it and don't number it, not enter it into evidence yet. Let me go on with the rest of my proof. And if by chance the respondent, through his representative, has admitted it in another exhibit, I may want to make another proffer relative to that exhibit.
Okay. Well, I'm not going to admit it right now for those reasons.
Right.
And if you can lay a foundation or find another way to admit it, then you're welcome to try to do that later on in the case.
Fine. Okay, we will call as our first witness Ms. Cody Best. VEST.
All right, Ms. Best, if you will come around here and have a seat. I need to swear you in first. Raise your right hand, please. Do you solemnly swear or affirm that the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right, Mr. Joseph.
Could you please state your full name for the record, ma'am?
Cody Best,
And what is your business address, Ms. Best?
500 James Robertson Parkway, Nashville, Tennessee, 37243.
And who are you employed by, ma'am?
I'm employed by the state of Tennessee.
Are you also an employee of the Department of Commerce and Insurance?
Yes, I am.
Are you the executive director for the Tennessee Alarm Systems Contracting Board?
Yes.
And how long have you served in that capacity?
4 years.
And did you work for the state of Tennessee's Department of Commerce and Insurance before that?
Yes, I did.
And what was your role with the state before becoming executive director for this board?
I was administrative manager.
And for how many years did you serve as administrative manager?
Sorry, about 12 years.
In your capacity as executive director for the Tennessee Alarm Systems Contractors Board, are you the official custodian of the books and records of this board?
Yes.
And does that include the board's official certification, licensing, and complaint files?
Yes.
Are you familiar with the respondent in this matter, CENTCOM Incorporated?
Yes.
And please explain to the board exactly how you are familiar with this company.
I received a complaint on, I don't have anything in front of me, I believe it's January the 18th of 2011, against CENTCOM doing business as. And since then, I have received an application for the company, and I have been working with this company to get them certified. Yes.
Is a copy of the document that I'm just showing you now a copy of the complaint that you indicated that you received in this matter regarding CENTCOM?
Yes, sir. This is my a copy of my online complaint form that was filled out on January the 18th, 2011, by Mr. Ronnie Pollard against American Digital Monitoring or CENTCOM Incorporated.
And did you receive this complaint?
My office said yes.
Did you print this complaint off?
Yes.
And is this document within your official books and records for the Alarm Systems Contractors Board?
Yes.
And do you have a business duty to maintain this document within your official books and records?
Yes.
Your Honor, we would move admission of the online complaint printed off by Mrs. Best, filed with the Regulatory Board section by Mr. Pollard as exhibit number 1 in this matter.
Any objection? All right, the complaint to Ms. Cody Best dated January the 18th, 2011, online complaint form regarding CENTCOM or Mid-South Security and Intercoms will be entered as exhibit number 1.
Mrs. Best, after you received this online complaint, which has been entered into evidence as exhibit number 1, what did you do after receiving this complaint?
Once I received this complaint on the internet, I sent it to our complaint coordinator, who then processes it, sends it out for response. We wait, I believe it's 30 days, waiting on a response to come in. Once the response comes in or does not come in, we send it to legal.
I'm sorry, Your Honor. Could I disseminate exhibit number 1 to the board? I
Yes,
did
sir,
not
you may.
distribute that to the board. Yes, this document be marked by the board. What is the document that I've just shown you, Ms. Vest?
You hadn't given me other than
Haven't
this
shown
one.
it to you yet.
That's okay. You started to. Yes, this is actually our complaint form that we send out that acknowledges the complaint was January the 19th, 2011. We send it to American Digital Monitoring care of Mr. attention Ronald Katz. It has the complaint number, and we notify them that we have a complaint that has been filed against him. And it has a complaint number, and it tells them who filed the complaint.
This is a copy of your office's letter of complaint to the respondent with a copy of the certified mail greeting card reflecting the respondent's receipt of the complaint.
Yes, it is.
And did your office send this letter out to the respondent on January 19, 2011?
Yes, we did.
Who is Hana Manan?
She's an administrative assistant, but she's a complaint coordinator.
Do you maintain true and correct copies of each of these documents within your official complaint and licensing files regarding the respondent?
Yes.
Do you have a business duty to do so?
Yes.
Your Honor, remove admission of the January 19, 2011 notice letter to the respondent sent by certified mail in the green certified card receipt as next numbered exhibit, which will be number 2.
No objection.
All right, the January 19th, 2011 complaint letter from the Department of Commerce and Insurance to American Digital Monitoring, along with the return receipt, signed return receipt, will be entered as collective exhibit number 2.
Did your office, ma'am, conduct any internet research regarding the respondent after you received this complaint in January of 2011?
Yes, sir, we did.
And what did you do?
We went out on the internet looking to see if we could find these names, and we did find the name of the company, Syncom, and we printed off the information.
What is
Your Honor, I'm going to object to
Your Honor, I want to build my foundation. I've asked her a question yet about the document.
Well, I'm going to object, Your Honor, because any question you ask her about hearsay is going to say hearsay. And this is a document that is clearly hearsay, just like the first one was. And there's no way to clean that up with her. There's no foundation that can be laid that will make
Okay,
hearsay.
this is going to be a lengthy objection that I'm going to have to ask the board to step out.
Well, there are going to
Gentlemen?
be several of these, and I don't know whether it's lengthy or not, but I have a response to it.
Okay, here's what we're going to do. I'm going to allow you to go ahead and try to lay your foundation. I understand that you have an objection. He's laying his foundation. Unless you actually elicit more hearsay, I'm going to allow you to go ahead and do that. And then if Mr. Morley still has an objection when you finish laying your foundation, then I will hear that. If it's going to be a lengthy discussion, then I'll ask the board to step out for a minute.
Well, it might be lengthy in as much as I understand the basis of his objection. My argument is that this constitutes a hearsay exception in as much as it is an admission by a party opponent. This document constitutes a statement by the respondent, and it constitutes an admission relative to the content of the document.
Right,
And-
so I'll let you go ahead and lay your foundation, and if that indeed is what it is, then I'll rule on that.
Thank you. What is the document that I just presented to you, Ms. Bass?
This is a computer printout, Syncom Incorporated, doing business as American Digital Monitoring UL Center. It's their printout of their computer system database.
Did your office print this document off on March 14, 2011?
Yes.
And does this document indicate information? Is this document maintained? Strike that. Is this document maintained within your official licensing and complaint files regarding this matter?
Yes, it is.
And does this document include On the second page, information regarding state licensing and referring to a Tennessee state licensing matter.
On the second page, under Central Station UL listing number.
Objection, Your Honor. This is unique rule, I believe, on voting on that's hearsay before she didn't say it.
All right. Well, as I look over this, it appears to be a website of the respondent, Centcom Inc., doing business as American Digital Monitoring. So for that reason, I'm inclined to believe that it's an admission and admissible. I'm inclined to admit it. All of this looks like a party admission to me.
Your Honor, setting aside, without agreeing with you, it's also not authenticated. In order for a document to be admissible, it has to be both relevant, not hearsay, and it has to be authenticated. And this document is not authenticated in any respect.
I think as a party admission, Your Honor, I don't think that requirement of authentication applies. That requirement applies to hearsay documents.
Well, authentication applies to any document that you're going to enter into evidence. However, something that's held out on a public website, okay, my ruling on this is that this is a matter which has been held out on a public website for anyone from the public to access, and is an admission by a party opponent, and therefore it will be admitted as exhibit number 3.
Thank you, Your Honor.
I reserve my objection to this.
It's noted, thank you.
Have distributed to the board.
Yes, you may.
Thank you. We ask that this document be marked as exhibit number 3. Page 2 of exhibit number 3, Ms. Bass. Do you find any mention of the respondent's state licensing?
Yes, sir. Down at the bottom, under Central Station UL listing number S24920, it lists several states. This is the title of state license. A lot of states.
What do you find that the respondent states about Tennessee licensing?
It says Tennessee-NA3600328.
What does the respondent state that the capital letters NA mean?
NA indicates license in process or not required.
As of the date these pages from the respondent's website were printed out by your office, which is March 14, 2011, had the board issued any certificate to this respondent to act as an alarm systems contractor?
No, sir.
As of March 14, 2011, had the respondent filed any application with your office seeking to be certified as an alarm systems contractor?
Can you repeat the date?
As of March 14, 2011,
No, sir.
had, as of March 14, 2011, had the respondent contacted your office in any way seeking information as to what the process to become certified as an alarm system contractor was?
No record of that, sir.
What is a copy of this document that I'm handing you right now?
Your Honor, if I could just give a blanket objection to the
Okay,
Internet.
here's what I'm gonna do. I'm gonna ask members of the board to step out for a minute so that I can hear argument on this. And I'll call you as soon as I can. I'm sorry for the interruption.
Do I need to step out?
Yes, ma'am.
That's all right. You know what I did on all those.
Oh, they all got it.
All, I
Okay. How many of these are there gonna be?
It's gonna, just like I've listed on our list of witnesses and exhibits, I've got 3 of them, 3 sets of them.
Why don't we just go ahead and address those right now then, while the board is out? Okay, your objection is the same objection I assume that you made to the first one, that it's not authenticated and that it is hearsay. Is that correct, Mr. Briley?
That is.
Okay, your response is,
My-
Mr.
As
Joseph?
I was earlier, Your Honor, in your previous ruling, I consider this an admission by a party opponent. This is a matter that was printed off from a publicly available website, and I think it's wrong-headed or impossible to expect the state to obtain any, if even there was a requirement for some certification, in as much as the respondent's owner and president is not present here. And I don't know of any requirement that would require a party opponent to request that opponent to certify that person's own internet document, which constitutes an admission. In my understanding, under Rule 803, that this document is excluded from the hearsay rule, and otherwise the document does not seem to be unreliable or inaccurate. And that was just the same as was the case on the first document that Your Honor ruled on.
Okay, go ahead, Mr. Briley.
For starters, the easy way for the state to have obtained this document in an authenticated fashion was to do a request for production of documents. This case has been pending for a long time. We could have done that. We also could have subpoenaed it from the URL provider. It is not authenticated, and in any respect, and there's no. I just looked at the authenticating rules, and there's no self-authenticating provision that would allow this to be admissible for proof. So I think and it goes to the core of their case. This is their case, and this is not. That's why. If it were something peripheral, I wouldn't be so adamant about it. I don't see any basis under the Rule 902 that would allow this.
All right. First of all, I believe it is an admission by a party opponent. So I believe that the materials printed off from CENTCOM's website on April 2nd, 2012, I believe they are an admission. With regard to authentication, that would be governed by Rule 901 and 902 of the Rules of Evidence. And while Rule 902 doesn't specifically state websites from a party opponent as being self-authenticating, it does talk about printed material from newspapers and periodicals, which are self-authenticating. And I wish the rules of evidence maybe were a little bit more up to date with regard to website activity. Unfortunately, it doesn't mention any websites, but I still consider this to be self-authenticating pursuant to Rule 902, just like an advertisement or an article by a company in a newspaper or a magazine would be. Your objection is noted for the record.
If I could just add a small thing. The reason that authentication should be required for this, look at the URL. It's ulcenter2shoppingcartplus.com page. It's not a website that purports to be Syncom Incorporated. I mean, the web address is not Syncom. The web address. And Your Honor, that's why some sort of authentication is required, because anybody could have gone out there and put this up. It's not anybody could have done this.
Well, Your Honor, let me say that the URL provider or the website provider is not the creator of the document. The creator of the document is Syncom Incorporated.
There's no proof of that in the record, Your Honor. The only proof in the record is the document itself. There's no proof in the record that anybody from Syncom created this. That's why it's a problem.
I would submit that Your Honor is precisely correct, that if this is the website for the company, I mean,
Well, a review of all the pages of the document. Every page references Syncom or American Digital Monitoring. It gives information about American Digital Monitoring, including how to apply or how to purchase American Digital Monitoring services. It talks about the services that American Digital Monitoring offers. It gives prices for these services. It has a standard dealer agreement that can be completed online. With American Digital Monitoring. Complete the form on page next to one of the last few pages that has a American Digital Monitoring new dealer sign up secure sign on form. So all the pages as they're reviewed indicate that it is an authentic American Digital Monitoring and therefore a Syncom document. So, for the reasons stated, I note your objection, Mr. Briley. On behalf of your client, it's going to be admitted as exhibit number 4.
should I bring the board back in, Your Honor?
Yes, please. Now, wait.
Yeah,
Wait.
there's one more.
There's one more.
That's right. And that would be the one that we printed off dated October the 2nd, 2010.
All right, and I'm assuming that you have the same objection for that. I don't have the document before me.
I have it right here, I just haven't numbered it yet.
All right, let me take a look at it. We'll go ahead and address that before the board comes back in.
While you're doing that, I will point out to the court that almost every page also says ulcenter.com, and it's copyrighted not to Syncom or American Digital Media. It's copyrighted to ulcenter.com.
And
That's why it needs to be open. I won't say anything else.
note your objection, Mr. Briley. And indeed, as Mr. Briley pointed out, you had asked for, you had sent out a request to admit that this was authentic, or you had sent out.
I did request that.
And we denied it.
Okay, well, I'm just now hearing that.
I mean, what does that have, I mean, I requested him to admit that it was admissible. He denied the admissibility of it.
No, you asked for it to be, and that it was authentic as well.
Well, you simply denied it. I still don't abandon my argument that it's an admission by a party opponent.
All right, well, here's what I'm going to do. I'm going to admit the April 2nd, 2012 collective exhibit is Exhibit 4 as a party admission. I'm going to admit the October 2nd, 2012 collective exhibit into evidence. I believe it's a party admission, and I believe that it is self-authenticating. However, I'm sure Mr. Briley is going to do a very fine job of cross-examining the witness when she starts talking about this, and I will allow you to argue that to the board, that it's not actually an authentic document or whatever you want to argue about that, Mr. Briley. And I'll instruct them that they can place whatever weight on it they wish to place on the two exhibits. All right, now let's call the board back in.
Okay, Your Honor, we took some of these out of order in terms of our numbering. The October 2nd one, I don't believe is going to be the next one in the ordering.
No, it would be the April 2nd, 2012 would be Exhibit 4.
Right, and October 2nd probably would not be Exhibit 5. I've got to see what I did with my list of witnesses.
Well, I'm not trying to mess you up, but it's going to be my Exhibit 5 because
Okay.
it just went on the record
Oh,
about
is that
it.
what you said? All right.
Yes, so
Well, that won't harm me because I haven't pre-marked anything else. I'm just trying to figure
Okay.
out where we are. October 2nd is Exhibit number 5.
yes.
All right. Okay.
And when the board comes back in and the witness starts talking about Exhibit number 4, I am going to go ahead and give them the instruction that they can give whatever weight they wish to on that, that the authenticity is disputed. Oh, no, go ahead. I hope I'm not talking too fast.
Oh, no, you're doing great. I just might not.
Be a Southerner, I just talk faster and faster. Again, thinking that I will get finished early, but that's not going to happen.
For the miss.
Excitement.
All right, members of the board, when the board left the room, there was an exhibit that was an issue, Exhibit number 4, which has been admitted into evidence. The respondent disputes the authenticity of the exhibit. For certain evidentiary reasons, the exhibit has been admitted into evidence. The board can give what weight, if any, it believes that this exhibit is entitled to receive, but it has come into evidence for the board's review. And the same, I'm not sure when Mr. Joseph is going to discuss exhibit number 5 or have the witness discuss exhibit number 5, but that will also, all of the same instructions that you just received on exhibit number 4 also apply to number 5.
Thank you, Your Honor. I'm passing out Exhibit number 4 right now.
All right, thank you. All right, Mr. Joseph.
Let me pass out and ask that this one be marked as Exhibit number 5.
All right, exhibit number 4 is the materials which have on the page 1, CENTCOM Inc. doing business as American Digital Monitoring. It's a multi-page document. And exhibit number 5 it's a collective document as well, and it's entitled "Existing Dealers Receive 6 Months Monitoring up to $5,000 free," and it has multiple pages which are attached after that.
October 2nd, 2012.
Yes, October 2nd, 2012. Thank you.
5. All right, Ms. Best, back on the record. Have you seen a copy of the document which was printed off by your office as exhibit number 4?
Yes, sir.
And what is that document?
It's a computer printout for CENTCOM, doing business American Digital Monitoring.
And that's a copy of the website printed on April 2nd, 2012.
Yes, sir.
What information do you find on the bottom of page 2 of exhibit number 4 relative to state licensing in Tennessee?
It says Tennessee, that has a number -NA3600328.
What does the respondent state on exhibit 4 as to what the initials NA mean?
It says NA indicates licensing in process or not required.
As of April the 2nd of 2012, had the board granted any certificate to be certified as an alarm systems contractor to the respondent in Tennessee?
No, sir.
As of April 2nd, 2012, had the respondent contacted your office in any way seeking information from your office as to what the process was to be certified?
No, sir.
Turning to exhibit number 5. Is this a copy of the respondent's website, which your office printed out on October the 2nd, 2012?
Objection, reading.
It is leading
All right.
price.
What is exhibit number 5?
Number 5 is a printout of CENTCOM website, American Digital Monitoring website,
What was the date this document was printed by your office?
October the 2nd, 2012.
On page 3 of this document, do you find any information regarding state licensing?
Yes, sir, down at the bottom, under that central station UL listing, it says Tennessee, and it has that number -NA3600328.
And what does the respondent state on page 3 of exhibit number 5 that the initials NA indicate?
NA indicates license in process or not required.
As of October the 2nd, 2012, has your office issued any alarm system contractor certification to the respondent, CENTCOM Incorporated?
No, sir.
All right. All right, at some point this year, Ms. Best, did your office ever receive an application from the respondent to become certified as an alarm systems contractor?
Yes, sir.
And when was that application received?
I don't have that in front of me, but I believe it was July this year.
Is the document which I'm showing you now a copy of the respondent's application to become certified as an alarm systems contractor which your office received in July of 2012?
Yes, sir.
keep the original signed copy of this application within your official application file regarding this respondent?
Yes, sir.
Do you have a business duty to do so?
Yes.
Looking on page 4 of this proposed document, is this document signed by a representative of the respondent's company before notary public?
Yes, sir.
Your Honor, we would move admission of the respondent's alarm systems contractor company application filed with the Alarm Systems Contractors Board on July 12, 2012 as the next numbered exhibit.
All right, the Alarm Systems Contractor Company application will be, which was received on July the 12th, 2012, will be entered as exhibit number 6.
What is the current status, Ms. Vest, of the respondent's application to become certified as an alarm systems contractor in Tennessee?
It's considered pending. Pending, excuse me.
Now, before you received this application from the respondent on July the 12th, 2012, had the respondent contacted your office in any way seeking information as to what the process was to be certified as an alarm systems contractor in Tennessee?
No, sir.
Have you ever told any representative of the respondent that it would receive a license or a certificate in this matter?
No, sir.
Have you ever told the respondent, in this case, that no alarm contractor certificate was necessary in order to provide monitoring services of Tennessee customers?
No, sir.
No further questions at this juncture, Your Honor.
Cross-examination, Mr. Brown?
Thank you, Your Honor. Ms. Best, did you say you've been here 12 years before you started as executive director? Or is it 12 years total?
No, I've been with the state, this is going on 20 years.
20 years.
But not in this capacity. I'm the executive director for other programs as well.
Oh, you are. Well, let me ask you this. In terms of familiarity with the alarm systems contractors process, is there anybody that's more familiar with that who's working for the state right now than you?
I have staff that may be more familiar with some of it, yes.
But you're pretty familiar?
I'm pretty familiar with it, yes, sir.
And the people who are more familiar report to you?
Yes, sir.
So if I ask you a question about how it works, you should know the answer to it, I suppose. Is that right?
Well, I
To how
have
the licensing process works.
for the licensing process, yes, sir. If you would ask me a technical question, it would be a different matter. Yes.
Same here.
All right, thank you.
Same here. Anything technical would be way out of my league. I want to take you back to the complaint, which is Exhibit 1. Have that in front of
Yes,
you?
sir.
And what's the date on that?
It says to Cody Best, January 18th, and it says to me, Cody Best, January the 18th, 2011, and the date was filed was January 16th, 2011.
All right.
That's what you're asking.
Yes, ma'am. And is it your sense from this complaint that the relationship between CENTCOM and Ronnie Pollard had stopped at this point when you received this?
Sir, I wouldn't even,
Well, from the complaint.
all I did was receive the complaint and file it. Now, what their relationship is with each other, that's not for me to determine.
Okay. Well, if you look at it, right after American Digital Monitoring, in that next line, it says, I had to change a company to a company that was licensed, right?
Yes, sir, I see that sentence.
So would you understand that to mean that Mr. Pollard was no longer doing business with CENTCOM as of the date of this complaint?
Not necessarily, sir. It said I had to change to a company that was licensed. I don't have a date there. I don't know what he meant.
Well, doesn't I had to change imply that it was in the past?
It could have, yes, sir. I have no, it doesn't give me a date to when he had to change to a company that was licensed. That's all it says. I had to change to a company that was licensed.
But it would be before the date of this complaint, right?
Yes, sir, I don't know. But
Really?
yes, sir. Okay, now this.
All right. So, after we ask the question this way then, subsequent to January 16th, 2011, have you ever heard from anybody else that in the state of Tennessee that they were doing business with CENTCOM?
No, sir, I have no recollection of anyone telling me.
No complaints to the department?
No, sir, not that I have.
No complaints from any consumers? Have you ever received a complaint from a consumer about CENTCOM?
Person, no, sir.
As a
Person.
department?
As a department, I don't have a record of that.
And you would know, you prepared today to come with
Yes,
us,
sir.
so you should know that today, right, if it had happened.
I have a record of it, yes, sir.
And Mid-South is in Mississippi. Mid-South Security Intercom.
I believe that's the address we have is Mississippi, yes, sir.
Now let me take you to these exhibits that are, let's start with exhibit number 2, which is some reports to the website for CENTCOM.
Is that exhibit 3?
2.
I must have mislaid.
Or maybe, is it this number?
Number 2 is the complaint letter.
Oh, I'm sorry, I missed number 3. Sorry about that. Even that is too technical.
No, so I just,
And you talked to Mr. Joseph about what's on the bottom of page 2. Now look at the bottom of page 4. Does it list licensing information at the bottom of the 4th page?
yes, it does.
Does it mention anything about Tennessee?
No, sir.
Okay, on this, these were printed, I guess, on 2 separate days, on the 10th and the 14th, at least they seem to be,
Yes.
of March 2011. As of March of 2011, do you have any information that CENTCOM or American Digital Media was doing, digital monitoring was doing any business in the state of Tennessee?
Not from this website information, sir, no.
Any information at all whatsoever?
Ask me the question again, so I understand exactly.
As of March 2011, does the Alarm Systems Contractors Agency have any information that would indicate that CENTCOM or American Digital Media was doing any business in Tennessee in March of 2011?
We just have one from the complaint. There was a complaint that was filed to tell me they were doing business, or indicating that they were doing business.
Right, and that was filed in January of that same year.
Yes, sir.
And that complaint says that he had already changed from using CENTCOM, correct?
No, it just said he had to change to a licensed company. I don't know what that means
All right. But,
to him.
okay, other than that complaint, you you have, which you suggest is unclear, do you have any other information that would indicate they were doing any business, that CENTCOM was doing any business in Tennessee as of March 2011?
No, sir.
And there, well, Exhibit 4 is also printed around April of 2012. Do you have any information that would indicate that CENTCOM or American Digital Media was doing any business in the state of Tennessee in April of 2012, other than potentially the complaint?
No, sir.
And the same question about Exhibit number 5, which is just from about a month ago, I guess, or 6 weeks ago, October 2nd, 2012. Do you have any information that would indicate CENTCOM was doing any business in Tennessee in October of 2012?
Other than my complaint, no, sir.
And the complaint says that it already changed to somebody else, right?
It says you had to change your license company.
And there's really not a dispute that CENTCOM is licensed. Nobody says they were, do they? Does anybody
They
say?
weren't licensed with us, no, sir.
Now, if CENTCOM wasn't doing any business in Tennessee, was a license required?
I'm going to object. I don't think that the witness testified that they weren't doing any business in Tennessee. She just said she had no knowledge of whether they were doing any business in Tennessee.
I said if they weren't doing any business in
I'll allow it, overruled.
If they weren't doing any business in Tennessee, were they required to have a license?
If they weren't monitoring accounts in Tennessee, the answer is no. They're not required.
And as of the dates of these websites, you have no information other than potentially this complaint that would indicate they were doing any work in the state of Tennessee. Are you aware of any harm that came to anybody in the state of Tennessee as a result of the alleged conduct of CENTCOM?
I haven't had any other complaints filed.
But are you aware of any harm that occurred to you?
I have not received any information to that effect.
Thank you. Nothing further.
I've got a question or two.
Redirect?
Yes, thank you. Ms. Vest, you just testified on cross-examination to Mr. Riley that if CENTCOM was not doing business as an alarm systems contractor in Tennessee, that there was no requirement for a license or certificate, correct?
Correct. Yes, sir.
What about if CENTCOM was advertising or holding itself out as providing monitoring in Tennessee? Would that require a license or certificate?
Yes, sir.
Thank you.
Any recross?
No, nothing further.
Mr. Joseph, is this witness excused?
Can the board members ask a question,
Oh,
Sean?
yes. Thank you so much. I always forget that and just rush right on. Members of the board, do you have any questions for Ms. Best?
I do, but I'm trying to think how to phrase it. Ms. Vest, the websites, there are several exhibits that have been printed out. You indicated, for instance, I'm looking at Exhibit 3. On page 2, where it lists Tennessee with a number behind it and the number being with the prefix NA. I guess a couple of questions. Would you, if you saw this, think that this company is licensed in Tennessee?
Well, sir, it does say it's state licensed and it'll list all the states. Then it has numbers behind it. If I were not in the business that I'm in, I may think that this company was licensed in Tennessee.
I'm sorry.
I may think this company was licensed in Tennessee. Excuse me.
Is real quick on turn back?
Because there's no speakers.
Oh, I have to speak louder, I'm sorry, my voice
Okay.
goes downhill.
Okay, thank you.
Any other questions from members of the board?
Just because I'm reading Exhibit 1, what I see near the bottom, I'll read the statement. What I see at the bottom, and I'm reading the statement says, I have notified Belleville about this incident. You can't hear me? I'm sorry. It's a statement on Exhibit 1. I've notified Beth Bell about this incident. She did advise me that this company was not licensed and had a previous complaint filed on them. And it's in Exhibit 1. So there was some previous complaints against this company.
I was not able to find any complaints against this company with this name.
Thank you.
Any other questions, members of the board?
If I were a consumer and I was looking at page 2, exhibit 3, with the NA references against with Tennessee, and I was looking at page 4, where Tennessee is not listed under UL, would I assume that they didn't have a license in Tennessee, or, and then after you mentioned that,
I don't,
it was in the,
my page, I got page 1, and I have page 2.
On 2,
Oh,
there's
okay,
numbers.
wait. Both of y'all can't talk at the same time.
Please refer to the exhibit that you're
Mr.
talking
Moore
about.
will not like it if you both talk at the same time. So,
Sorry.
okay, so I know it's easy to anticipate, you want to answer what you think is going to be asked, but if you will let Ms. Jones ask her question, and then you can answer it.
Thank you.
If I see numbers beside Tennessee on page 2, and no numbers, or Tennessee's name on page 4, on the central station jail listing, would that leave you believe they're not listed, or not licensed, or not able to practice in Tennessee?
That's kind of, if I was a consumer on one page, I see a number, and then on another page, I don't, I would try to find out what the discrepancy was. Why would it be on one page and not the other?
So this is just an informational thing, that if you're a contractor and you're licensed in monitoring, aside from the other classifications, you have to be well listed and have a Tennessee license,
You have to have a Tennessee license, yes.
but you don't have to be UL.
I'm not familiar with the
Okay, that's what I was trying to find out.
Can I follow up on one of the questions?
I'll let there be follow-up questions, I promise. Any other questions from members of the board?
Yes, I have one other question for you. Real fast on Exhibit 6. This is the application from CENTCOM. Is that correct?
Yes, was the application, copy of the application.
Okay. I know there's been some discussion about the admissibility of stuff printed off the internet, but on Exhibit 6, the last page of my attachment, it starts at the top, join now.
Yes, sir, I have that.
That information was submitted by CENTCOM
This is a
as
complete
part of their
application.
application.
Yes, sir, this is a completed application, but everything was in the file.
And that was submitted by them, wasn't printed off the internet or something. Is that correct?
No, sir, if you look at the top, it does have a internet but the whole application could have been printed off the internet.
No,
Signed.
he's asking, is this application in totality received from CENTCOM, or did the state make any copies and attach to this application?
I would, but as far as that sheet's concerned, I'd have to look in the file to be sure.
Okay, but so you're not in a position to tell me whether or not that sheet was submitted as part of the application or not?
Correct. Not without looking at that, because I do have a completed application, but that looks like a computer printout to me.
Okay. Does that information there also include Tennessee with a number and the preface with the NA and such that we've discussed on the internet printouts that the state printed out?
Yes, sir, it has the same number.
So that has the same information then that the state printed out off of its internet?
Yes, it's the same
And
information.
if this then had been submitted as part of CENTCOM's application, that would be information they provided, would it not?
Yes, sir,
Or is that correct?
that's correct. They were provided.
Thank you.
Any other questions for Ms. Best, members of the board? Mr. Roberts?
No, I'm thinking that, I don't believe the question. I thought was really thought correct.
Okay. Council, follow-up questions, Mr. Joseph? Mr. Briley?
One, maybe two. There were some questions about whether or not a consumer would be confused. Do you know who CENTCOM sells to?
No, sir.
Do you know if they sell to individual consumers?
No, sir.
Do you know if they only sell to dealers who've already sold to the
No, sir.
consumer? You don't know. Would it change your opinion about the likelihood of confusion if you knew that CENTCOM only sold to other alarm dealers and didn't sell to the public?
No, sir.
Any follow-up, Mr.
Yes,
Joseph?
yes, Your Honor. Thank you. Ms. Vest, you were asked a couple of questions by Ms. Jones about Exhibit number 3. I want to follow up on a few of those. You have Exhibit 3 before you.
Yes, I do.
All right. You were asked about the fact that Tennessee, designation for Tennessee is included on page 2 of this exhibit, but that Tennessee was omitted on page 4. Do you find any reference to Tennessee licensing on the final page of this exhibit, which is page 6?
Yes, sir.
And what do you find?
It still says Tennessee with that NA 3600328 number.
All right. Now let me ask you another question or two about exhibit number 6, the respondent's alarm system contractor application. On the first page of exhibit number 6, what did the respondent state under item number 2, general information, that its company web page address was on exhibit number 6?
www.ulcenter.com, C-O-M.
And this application was submitted to your office?
Yes, sir.
Thank you, Ms. Vance.
One follow-up then.
Mr. Briley?
Ma'am?
Yes, you may.
Do any of the web sheets that are exhibits have the actual address ulcenter.com?
Down at the bottom they do, yes.
Could you read that one?
www.ulcenter2.shoppingcartsplus.com.
I'm sorry, excuse me.
To the number 2
Okay.
dot shoppingcartsplus.com.
Thank you.
Any other questions, members of the board or council?
And I'd just like to make a note of the question, Ms. Bess. I don't know about those copies, but each of my copies has the same web links on the page of each of these. Other than at the bottom.
Certainly not.
I feel like I'm being a nuisance.
No.
Tend to be engaged. And again, I'm looking at Exhibit 3, which we just mentioned. The third page there. My sheet looks a little clipped off on one side there. Ms. Bess, could you read the first paragraph there that starts American Digital Monitoring? Could you read that paragraph, please, ma'am?
American Digital Monitoring provides professional alarm monitoring services nationwide, including Alaska, Hawaii, Puerto Rico, Guam, and Canada, with our multiple interlinked monitoring centers
I'm sorry,
located. Right, too fast.
After, and Canada, over there.
With our multiple interlinked monitoring centers located throughout the United States.
The reference there where it says nationwide, and then they go on to include specifically Alaska, Hawaii, Puerto Rico, so forth. Nationwide, what does nationwide mean?
If I was reading this, nationwide means the United States.
All of the United States?
Which, yes, sir.
Any exceptions?
No, sir.
Okay.
Anything further? Mr. Joseph, is this witness excused?
Yes, Your Honor, I finished with Ms. Bess.
All right, Ms. Bess, I believe you are free to go. Free to stay then.
We take a 5
Yes, let's take a 5-minute recess.
Thank you.
Next witness.
Our next witness will be Ronnie Pollard.
All right, Mr. Pollard, I need you to have a seat over here, that table. You can take your water with you if you want to. And I need to swear you in first. Raise your right hand, please. Do you solemnly swear or affirm that the testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, Mr. Joseph.
Your Honor, we do have exhibits 1 through 6, which have already been evidence over there in case I need to ask this
Yes.
witness anything about it. Any further? Good morning, sir.
Good morning.
Could you please state your full name for the record?
They're Ronnie Pollard. Ronnie Wayne Pollard, actually.
What is your business address, Mr. Pollard?
It is Post Office Box 1356, Olive Branch, Mississippi, 38654.
Sorry, 356.
54.
What is your profession, sir?
I own an alarm systems installation company.
Do you own an alarm systems company by the name of Mid-South Security and Intercoms?
Yes, sir, I do.
Where is Mid-South Security and Intercoms located?
In Olive Branch, Mississippi.
Does Mid-South Security and Intercoms have a certificate to practice as an alarm systems contractor is issued by this board?
Yes, sir, it does.
And when was this certification issued?
Since the birth of having to have a license in Tennessee.
What is Mid-South certification number?
244.
And when does Mid-South's alarm systems contractor certification expire?
I believe it is, I want to say it's December or January coming up. Either December of this year or January of 2013.
What classification is your company allowed to do alarm contracted work in Tennessee?
Burglary.
Sorry, I didn't hear you.
Burglary.
Oh.
Yes, ma'am.
Do you have Tennessee client accounts, sir?
Yes, sir, I do.
And where are your Tennessee client accounts located primarily?
Memphis, Germantown, Collierville area.
How many Tennessee accounts do you have presently?
Approximately, probably 200, 150, 200.
How many Tennessee accounts did you have in 2001?
And the neighborhood of around 100 to 150.
How many total client accounts did you have in 2001?
2001, probably in the neighborhood of about 350, maybe probably about 3 to 350.
How many do you have now?
Currently,
Yes.
470, I believe it is.
Are you the designated qualifying agent for Mid-South Security and Intercom, sir?
Yes, sir, I am.
How long have you had a qualifying agent license in Tennessee?
The same, since it was required by law.
Is your Tennessee qualifying agent license currently active?
Yes, sir, it is.
Are you familiar with the respondent in this matter, CENTCOM Incorporated, doing business as American Digital Monitoring?
Yes, sir, I am.
And how did you first become familiar with the respondent?
There was a magazine ad, and then also shortly after I saw him in a magazine ad, I received a phone call soliciting my business.
Who was the representative of the respondent's company that first initiated contact with you, soliciting your business?
I do not recall
Approximately when did this occur?
that. In 2001, the end of 2001.
What were you told by the respondent's representative?
That they would monitor.
What's your response, Mr. Joseph?
So what is the nature of the objection?
Here, sir.
What was he told by the respondent's representative? My response is that it's a statement by that constitutes a party admission.
Mr. Riley?
I asked him, what did the representative say?
Mr. Riley's correct. He didn't say who it was that called, and you don't know if the person that called was high enough up the chain of corporation or the company that it could actually be an admission by a party opponent. You can rephrase.
Say again.
You can rephrase. The objection is sustained.
What is your well, I can rephrase. What caused you to first have any contact with any representative from the respondent?
What caused me to have
Yes.
contact? They made contact with me.
Why did they make contact with you?
They made contact with me to solicit my monitoring business.
What did you do next?
We ended up getting on board with them and allowing them to monitor our accounts.
When did this occur?
This occurred late 2001 to early 2002.
What was your understanding of whether or not the respondent was certified at that time in 2001 to perform alarm systems contracting work in Tennessee?
I was told on the phone that they possessed a certificate to work in the state of Tennessee, and it was also displayed on their website.
Did you do any other research on your own to determine whether or not that was in fact the case with this board?
No, sir, I did not.
Why did you not?
I did not have any reason to doubt at that point, it being told twice and being told on the phone and seeing it on the website.
When did this oral agreement that you just testified to go into effect?
It would have been late 2001, early 2002.
How many Tennessee client accounts was respondent monitoring you in late 2001?
Probably 100 to 150 at that point.
How long did the agreement that you reached with the respondent in late 2001 stay in effect?
Till 2010. Probably the summer of 2010, I believe it was.
Did there ever come a time in which you signed a written wholesale monitoring agreement with the respondent to allow the respondent to monitor your company's accounts?
Yes, sir, they did.
Copy of the document which I've just presented to you, a copy of a wholesale monitoring agreement you entered into and that you signed on behalf of your companies with the respondent CENTCOM? I asked him, is that a copy of the document that he signed? I don't think it's legal. The answer, it can be answered yes or no.
Upload.
Yes, sir, it is.
Do you maintain a true and correct copy of this document within your official business records? Business's records as the owner of Mid-South Security?
Yes, sir, I
Did you sign this document?
did. Yes, sir, I did.
And what did you do with it after you signed it?
I filed it in our filing cabinet.
We asked that the wholesale monitoring services agreement between CENTCOM Incorporated and the complainant's company, Mid-South Security, signed by Mr. Pollard on February 12, 2010, be entered into evidence as the next numbered exhibit, which would be exhibit number 7.
All right, the contract between Wholesale Monitoring Services and American Digital Monitoring will be entered into evidence as exhibit number 7.
Mr. Pollard, how long did you operate under this written wholesale monitoring services agreement with the respondent CENTCOM?
Just a few months, approximately probably 4 months.
Would that be July of 2010?
Yes, sir.
What occurred to cause your company to cease operating under this written monitoring agreement?
They did not stay true to the agreement, and I also found out factually that they were not licensed in the state of Tennessee to provide the service. So therefore, I found a company that was.
And when did you find out that they were not certified as an alarm systems contractor in Tennessee, sir?
It was right around June, May, June, right in that area.
And how did you find that out?
I spoke with Mr. Ronald Katz himself.
What did you do next?
Of course, I received suit being filed.
Please keep your voice up.
Oh, I'm sorry.
Before you hear.
I received suit. Is this working? Okay.
No,
I
the
received.
microphones don't work, you just need to project.
Okay. I received
Especially so
a.
that the board members can hear you.
Gotcha. I received a suit that was filed against me, which was delivered to my wife's place of business to us. Shortly after that, I received a settlement from them asking me to sign, basically trying to settle it out of court, and I refused to sign that also.
There's a copy of the document I'm showing you now, a copy of the lawsuit which was filed against you, your wife, and Mid-South Security by the respondent, CENTCOM.
Yes, sir, it is.
And when were you served with this lawsuit, sir?
I believe it was October, the end of October,
Of 2010?
2010, yes.
Your Honor, we would move admission into evidence as the next numbered exhibit, which would be exhibit number 8, a certified copy of the Superior Court of Washington for King County civil action in the matter of CENTCOM versus Mid-South Security, Ronnie Pollard and Lisa Pollard.
Any objection? All right, the certified copy of the complaint for CENTCOM versus Mid-South Security in the Superior Court of Washington for King County will be entered as exhibit number 8.
What happened after you were served with this lawsuit, sir?
That's when I actually received the settlement, trying to get me to settle out of court with them and to actually help them obtain a Tennessee license.
The document which I'm showing you now, a copy of a proposed general release and settlement agreement that was faxed to you by the Respondents' Council in November of 2010.
Yes, sir, it is.
You received this document?
Yes, sir, I did.
Your Honor, we would move admission as the next number exhibit, a copy of the general release and settlement agreement proposal faxed to respond to Mr. Pollard in this action, in King County civil action as the next numbered exhibit.
That would be exhibit number 9. Any objection?
No.
All right, the general release and settlement from CENTCOM to Mid-South will be entered as exhibit number 9.
All right, Mr. Pollard, after you were served with this lawsuit, which is Exhibit 8, and you received this general release and settlement agreement proposal, which is Exhibit 9, what did you do next?
I retained counsel in Seattle, Washington to represent our company.
Did you sign this general release and settlement agreement that was presented to you as Exhibit 9?
No, sir, I did not,
Why did you not do that?
because they would have continued to hold me in violation of Tennessee state law if I would have signed it.
And why do you feel that way?
Because I can't legally assist a company that's already illegally doing work and trying to become legal. And plus, I would have had to place all of my accounts back with them according to the settlement, which would have in turn put both of us operating in an illegal fashion.
Did you ever assist the respondent in any efforts for the respondent to obtain a certificate as an alarm systems contractor in Tennessee?
No, sir, I did not.
After you ceased doing business with respondent in the summer of 2010, did you ever again allow respondent to begin monitoring your Tennessee client accounts?
No, sir, I did not.
When you first began doing business with the respondent in November of 2001, what efforts did you engage in to determine whether the respondent was certified as an alarm systems contractor in Tennessee?
Well, as I said, they told me on the phone that they did have a license to operate, and it was also posted on their website that they had a license along with the number beside it, under state licenses.
I'm sorry, the last part of what you said.
On their website,
That they had a license.
they had a license displayed on their page that's under where it said state licenses, and they had a number out beside it as if it was an issued license number.
Did you later submit a complaint against the respondent in January of 2011 with this board?
Yes, sir, I did.
I want you to look at a document which has already been entered into evidence as exhibit number 1. Is that a copy of the complaint that you submitted to the board against the respondent? Online?
Yes, sir, it is.
At the time in which you submitted this complaint, were you still doing business with the respondent?
No, sir, it was not.
What happened with the Washington State lawsuit that was filed against your company and yourself?
It was dismissed.
No further questions at this time, Your Honor.
Cross-examination?
Thank you.
Mr. Paul, we met before, we were talking a little bit all and such.
They did.
I'll try and get you out of here so we can get on back to Mississippi. Just for the purpose of clarification, can you tell the board exactly what kind of business you're in as opposed to the kind of business that CENTCOM is? And what's the difference between the two companies?
I do installations. We install security alarm systems. CENTCOM actually monitors. They are a subcontract monitoring company.
So in that context, would CENTCOM have a contract with the individual business, or would they only have a contract with you? Back when they were working with you, did they have any contact directly with the purchaser of your service?
I'm not sure I understand your question.
Okay, well, probably because I didn't ask it well. I'll concede that. So you said that you're in the business of installing burglar alarms. Is that right?
That's correct, yes.
In that context, I assume you have a contract with the company that's purchasing the installation, right?
Right, yes.
Does that contract also say that you will service the alarm?
Yes.
Okay. Does CENTCOM...
And I'm sorry. Some of my contracts say I will service it. Not all of my contracts, they have an option for service or not.
So, did CENTCOM ever have a contract with any of your customers that you would install the burglar alarm for?
With them directly?
Correct.
No, sir.
CENTCOM just had a contract with you.
Yes,
That's the only one.
that is correct.
Did you ever disclose to any of your customers that you were using CENTCOM?
No, sir, did not.
How, as a practical, technical matter, who were you using to service your alarms before you used CENTCOM?
I was using,
why did you stop using it?
Because of the rate that I was offered from Syncom.
And when the service switched from the previous provider to Syncom, as technically as I started, how did that happen? What technically happens for the service to go from one provider to another?
You redirect your 800 lines to that new provider.
So when a burglar alarm goes off in a restaurant in Germantown, that system there dials a 1-800 number, and it goes to Syncom. Would Syncom automatically did you have to go out to each individual location and reprogram something, or is that something you could do remotely for all of them at once?
No, it's all of them report through an 800 number that is mine. So all of them report to an 800 number that is mine, so that I can redirect that 800 number to wherever I need to.
Now, that contract that you had with Syncom starting back in 2001, allegedly, that was in violation of the licensing regulations, wasn't it? The state statute.
The verbal contract?
Yeah.
Yes.
Absolutely. So you were in violation.
Yes, I was.
Have you received a notice of a complaint against you or any sort of proceeding against you?
No, sir, I have not, because I was misled on that.
All right. Well, I think the code prohibits a joint venture between a licensed and an unlicensed alarm contractor, correct?
It does, yes.
Don't you think that would impose some sort of obligation on you to determine if your joint venturer had a license?
I was told by them that they were licensed, and then also on their website, they indicated they were licensed with a number beside it, so therefore led me to believe that they were legitimately licensed in the state of Tennessee.
But it's a violation of the law for you to be licensed, to engage in that conduct if they're not, right?
That's true, yes.
And it would have been easy for you just to call up to Nashville and find out if they were licensed, right?
Yes, it would have been easy, yes.
But you didn't do that.
No, sir, I did not.
I'm sorry, let's see what number the contract is up there. That might be exhibit number. Check. Have this one.
7 is the contract.
7 is the
Seven is the
contract.
contract.
Yep. When you completed this contract, it required you to put the address of your business on there, right? And you did that accurately, correct?
We did.
And could you tell the board what that address is?
Post Office Box 1356, Olive Branch, Mississippi, 38654.
So when you entered into a contract with Syncom, you actually entered into a contract with them in Mississippi, wasn't it? You entered into it in Tennessee, wasn't it?
That's correct.
And
I was in Mississippi, yes, when I signed the paperwork, yes.
And Syncom was in Washington, right?
Yes.
Now, why did you wait for months after you learned that they were not licensed to file a complaint against them?
Didn't wait months. It was, I actually filed the suit, after they filed the suit on me is when I actually moved everything. I'm sorry, you meant when I filed the complaint.
Yes.
Because they continued to harass me and everything. And plus, it was my civic duty and what I'm supposed to do as required by law. If I find somebody violating it, I'm supposed to report it.
Well, that doesn't answer my question about why you waited from, I think you said you ended the relationship with them in October of 2010, and you didn't file a complaint against them until you had hired a lawyer in Washington State in January of 2011. Isn't that right? Didn't your lawyer tell you to do that?
No, sir, he did
He didn't? Wasn't it just to get leverage in the litigation?
not. No, sir, it was not.
But you did wait until you had a lawyer in Washington.
Yes, yes, but that actually has no bearing on it.
You said back in 2001 you had between 100 and 150 clients in Tennessee. Did CINCOM service all of those?
Yes, sir, they did.
How much did they charge you?
$1 per account.
Sorry, what now?
$1. In the beginning, they charged $1 per account, then they steadily escalated it up.
And that's why you ended the relationship, right?
Yes.
You didn't end the relationship because they were unlicensed. You ended the relationship because they were charging you.
No, sir. No, I ended the relationship for the two reasons that I stated. One of them is the fact that they did not hold true to their end of the contract. The other one was that I also found out that they were not a licensed entity in the state of Tennessee.
Correct.
Mr. Pollard, how many of your client accounts that you had in 2001 were accounts in Mississippi?
In Mississippi, probably about 250 to 300.
And how many were in Tennessee at that time?
In 2001, 100 to 150.
And was the respondent CINCOM, once you entered into the oral agreement with them in 2001, monitoring all those accounts?
Yes, every one of them.
In 2010, in the summer of 2010, you terminated services with the respondent. How many Tennessee accounts did you have at that time?
Probably approximately 200.
And how many of your client accounts were in the state of Mississippi?
About roughly a little over 3. Or right at 3, something. Right in that area, right about 300.
That's all.
Request. Members of the board, do you have any questions for Mr. Pollard?
Yes, I have a few questions.
Okay.
Mr. Pollard, the contract, which is Exhibit 7, the copy that you presented here, you signed, is that correct?
Yes, sir.
Did you ever receive a signed copy back from American Vision Monitoring?
No, sir, I did not.
Do you know if CINCOM was monitoring any other Tennessee counties?
I do not know that for sure. I have been told.
Objection, calls for hearsay.
So you don't know of any, you don't personally know anybody else that CINCOM is monitoring Tennessee counties?
No, sir, I do not.
As a result of this experience with CINCOM, were you harmed in any way?
I would say emotionally. Anytime you have a $250,000 lawsuit brought against you, you lose sleep. So you're not physically harmed, no, sir.
Were there costs that you incurred as a direct result of this relationship?
Yes, sir, there was.
Were they substantial, or do you have any estimate of what might have been involved there?
Yes, sir. Attorney's fees in the neighborhood of $7,000.
Do you know whether or not any of your customers were harmed or inconvenienced in any way as a result of the changes and result of this experience at SECCOM?
No, sir, they were not. I made sure that they were not.
You mentioned a few minutes ago that you could not, as a designated qualifying agent in Tennessee, you were aware of the fact that you could not partner with an unlicensed entity to provide services.
Yes, sir, I was.
I believe that's my question.
I've got two questions.
All right, Mr. Tucker.
Second. Mr. Pollard, did you tell American Digital or with the state or somewhere that you had customers in Tennessee?
Yes. It was.
When your monitoring agreements, were they in your company name or were they American Digital where you had to fax them off?
No, they were in my company name.
So how did American Digital know who to respond to?
Well, we'd go in and actually put all the information in, or turn it in on the paperwork, then they would enter it into their database, or we would go online and enter it into the database as to who the responding parties would be.
I'm sorry, that's you.
The responding parties would be.
Okay.
So they knew these, which state the client
Which state these customers
resided.
were?
Yes.
That's the question.
Yes, sir.
Okay, thank you.
Any other questions for this witness, members of the board? Follow-up questions, counsel? Mr. Joseph?
I don't have any follow-up questions, Your Honor.
Mr. Briley?
No, no.
All right, is this witness excused?
I think this witness is excused, Your Honor.
Thank you very much, Mr. Pollard. You are free to go or free to stay. Call your next witness.
Your Honor, we don't have any further witnesses.
All right, is the state rest?
Well, we'd like to re-urge the admission of a document which was previously not allowed into evidence. If Your Honor remembers, initially we had proffered the Corporations Division, Corporation Detail document from the Washington State Secretary of State's office. Let me make the argument, Your Honor. If Your Honor notes on its...
You've already made the argument.
No, I haven't, because this document has not come into evidence. If Your Honor looks at the exhibit number 6, which was entered into evidence as the respondent's application, the respondent itself on this application on page 2 indicated that the respondent has a State of Washington incorporation of 112196, which is the same information contained on the Corporation Division printout, which is admitted. The respondent admits, as we have stated earlier, as exists on this Corporation Division detail page, that Mr. Katz was the agent. Respondent states that Mr. Katz is the designated qualifying agent on page 1. The respondent has also attached within 3 pages from the back of Exhibit 6 its own certification from the Washington State Secretary of State's office, which was received by this board within the application, authenticating the information that the state submits on the first document, which we submit is the same information, and that the respondent has admitted it, and that this corporation detail document from the Secretary of State's office indicates the same information that the respondent's already submitted and that has been admitted.
Right, so you've had admissible evidence admitted. I'm still not going to admit the first exhibit that was under discussion because it says it could be untrustworthy and not to rely upon it. And to do so would be at the individual's own risk. No.
Okay, all right.
Everything that you want into evidence is in evidence in Exhibit 6, which has already been admitted. No.
I think that the fact that it's in the Exhibit 6 indicates that it wasn't trustworthy initially, but it's all right.
All right. Closing argument?
We have proposed findings of fact and conclusions of law. Can we submit those to the board?
Yes, sir. I need to get the board charges, so let me do that first, and would you make closing argument?
I didn't say I was waiving. I said I'd like to submit
Oh,
some proposed
I thought you were
findings.
waiving. I'm
I didn't say I
sorry.
was waiving anything. I just wanted to know when Your Honor thought the appropriate time was to speak.
Usually I have closing arguments, then I give my instructions, and then you can submit any proposed findings.
Okay.
That way, not to say that this board would do that, but some boards tend to start reading the proposals and not listening to closing arguments, and so I'm sure y'all wouldn't do that. Okay.
Thank you.
Closing argument?
Thank you, Your Honor. Members of the board, briefly, the state submits that it believes it's proven all of the allegations as included within the notice of hearing and charges, at least by a preponderance of the evidence. The evidence that you've heard before you today indicates quite clearly that the respondent has never had a certificate to operate as an alarm systems contractor in the state of Tennessee. The 3 copies of the respondent's website, which have been admitted into evidence and which constituted advertisements for the respondent's services, all indicate, as the state has stated in its notice of hearing and charges, that there is a state of Tennessee licensing number, and the NA information which the state submits is misleading and inaccurate. This information was existing on the respondent's website as early as March of 2011 and continues to exist through October the 2nd of 2012, which is 5 weeks ago. The state submits that that constitutes holding oneself out as an alarm systems contractor in Tennessee. The statutory provisions indicate that the respondent can violate the section, that one of the sections that was cited by the state, Tennessee Code Annotated 6232.304A, by not only engaging in the practice as an alarm systems contractor without a certification, but by holding oneself out as an alarm systems contractor without a certification. I think the undisputed proof sets forth that the respondent provided services to Mr. Pollard's company in providing monitoring to Mr. Pollard's Tennessee clients from November of 2001 through July of 2010, a total of 103 months as the state has alleged previously. I think the proof shows that from March of 2011 and October of 2012, that the respondent held itself out as engaging in the business of an alarm contractor in Tennessee as a separate violation for a total of 20 months. And the state submits that the proof is undisputed that the respondent failed to submit an application for certification to this board after it was practically operating as an alarm systems contractor, as is required by Rule 0090, 0104, and 009001.07. We have previously requested the imposition of civil penalties in this matter. It's clear from the statutory scheme that the conducting of monitoring of alarm systems is within the business of an alarm systems contractor as defined by Tennessee Code Annotated provisions. The respondent engaged in this conduct for between 8.5 and 10.5 years. And the claim that licensing was in process was inaccurate. No application was filed for many months, but in any event, licensing could certainly not be stated by a respondent to be in process because it's not clear that the respondent would have ever received the license. In short, the state believes that all of these violations have been proven and that under Tennessee Code Annotated 6232 320B, when a violation of 6232-304A and J are proven, which involve unlicensed conduct or holding oneself out as a contractor without ever being certified, that those violations can result in a civil penalty of not less than $1,000 per violation, nor more than $5,000 per each occurrence. The state would submit that every day these accounts were monitored could constitute a separate violation, but the state's only requested in its prayer for relief that the board characterize the violations as being one per month. Furthermore, the respondent's violations of the board rules that we previously cited pursuant to Tennessee Code Annotated 6232-320C indicate that this board may impose a civil penalty of up to $5,000 for each separate violation. The state's prayer in that regard is that the failure to submit an application until July of this year be punished at the rate of only $100 per month, which we submit is a very low civil penalty figure. But these violations continued unabated for many years. It's clear that monitoring is within the business of an alarm systems contractor in Tennessee. Respondent was not certified. We asked the board to so find, and we asked the board in its judgment to assess the cost of this clause, including the cost of the Administrative Procedures Division and the cost of the court reporter against the respondent. Thank you.
Mr. Browning, closing.
Thank you. The only contractual relationship between CENTCOM and any entity that's been proven today is an agreement that took place in Arkansas, not in Tennessee. No Tennessee company involved. There was an agreement between CENTCOM, a Washington company, and Mid-South, a Mississippi company. It was entered into in Mississippi. Its provisions are not governed by Tennessee law. There's no Tennessee contact with this in this contract. The only relationship between Tennessee and CENTCOM is that Mr. Pollard, a seemingly sophisticated alarm contractor, in violation of Tennessee law, which he had an obligation to know, entered into a contract that violated that law. Now, for a decade almost, he was happy about that. It was all good. That only became a problem when the rates changed, and they got into a dispute about who owed who what. Up until that moment, there had been no harm to anybody in Tennessee. And frankly, I think it's fair to assume that this would never come before the board if there hadn't been this dispute about money. The only harm that has been demonstrated is that he had to pay $7,000 in attorney's fees because there was a dispute about who owed who what. Not because somebody's alarm hadn't been answered, not because service had been poor, but because there was a dispute about who owed who what money. There's no proof, no document that demonstrates that any business has been conducted in Tennessee in the time period of these websites that are printed out. Now, we've objected to the websites, but I understand the ruling, and they're before you. They are not, however, conclusive. Even under our rules of evidence, and these, if they are before you, they are not conclusive, and you don't have to accept them as being true. Let's just assume for right now that they were made by CENTCOM, however. These are not representations to individual businesses, to consumers. These are representations to alarm servicers, to people who are installing alarms. Now, assume that the statement of licensed insurance is confusing. Because I submit that what you have in front of you is confusing. On one page it says they're not licensed. On another page it says that license is not required. or is in process. Now, if you're not doing business in Tennessee, actually a license is not required here. So and during the time period for these websites, there's no evidence that any business was being conducted here. So a license was not required. It's not a mistake. No license was required if you're not doing business in the state of Tennessee. And there's no evidence before you, none whatsoever, that from the spring of 2011 to today, that any business has been conducted here. So it's not inaccurate. It is accurate. No license was required because no business was being conducted. So it would be an error, in my opinion, for the board to find that the websites are in any way a statement that they are conducting business in Tennessee. Now, coming to the issue of harm, coming back to it for just a second. This complaint and this enforcement action is secondary to a contract dispute. It's not something that was initiated because of harm to a party, harm to a business who's alarmed. This is just collateral to a business dispute. A business dispute that the complainant accepted for a decade. He was okay with it for a decade. Now he violated the law too. No complaint against him, no proceeding against him. So for the board to do anything to CENTCOM during the time period when the complainant was benefiting personally from the relationship with CENTCOM does not seem to be fair to me. Why would you let him accept the benefit of this relationship during the entire course of it? And then after he's done with it, then, oh, I'm going to complain and drag you down too. Without also bringing him before the board and saying, you benefited from it. You were the one who were licensed to. You knew the rules. You should have looked into it. You should have been the one responsible for this. You were the one selling to the consumers. You were the one putting the consumers at risk potentially. Why didn't you do something? But instead, we're looking only at one side of this equation. So, if the board finds a violation, there is only one violation, and that violation is the contract between CENTCOM and Mr. Pollock's company, Midtown. The maximum the board can award for that is $5,000. And I would say that because there is no harm here, that the board should award no more than $1,000 in civil penalties for this company.
Anything further, Mr. Joseph?
In the way of a short rejoinder, the state would submit that the board's civil penalty rules, which the state has cited in the notice of hearing charges, do not require that there have to be harm before a civil penalty can be imposed, and that the statutes that the board has cited indicate that if there is a violation, that the minimum civil penalty shall be of a certain amount, a minimum of $1,000 for unlicensed conduct. Secondly, it is clear, given Mr. Pollard's testimony, that Mr. Pollard indicated, and the record reflects that he has a Tennessee license as well as a Mississippi license as an alarm systems contractor, so that there were Tennessee clients being serviced, Tennessee business, even though his business may be physically located in the state of Mississippi. So it's clear that Tennessee has a nexus in this case. Finally, as to the assertion that there can be no violation by the respondent of any advertising contained in the websites if the respondent is not engaging in the business in Tennessee, I submit that that is not the case. The statute 6232-304A indicates that no person shall engage or hold oneself out as engaging, and that the websites constitute advertisements. They reference a Tennessee licensing number or some information regarding Tennessee licensing, and that is the holding out of doing alarm system contractor business in Tennessee. Thank you.
All right, if council has proposed orders, proposed findings of fact, conclusions of law for the board, if you will distribute those at this time.
I did not prepare anything for today. Based on the decision of the board, I'll be glad to prepare findings of fact.
All right, members of the board, it's my duty now to charge you. The board has heard the proof in the case of CENTCOM doing business as American Digital Monitoring. It's now my duty to charge you regarding the law which you must follow in reaching your decision. You are the exclusive finders of the facts in this case, and you are also the exclusive judges of the application of state rules and statutes governing alarm systems contractors in the state of Tennessee. As sole and exclusive finders of fact in this matter, you must conduct open deliberations, make findings of fact, and reach conclusions of law. You must determine the facts based upon the evidence presented. Based upon the facts adopted by the board, you must then decide whether or not respondents' acts or omissions constitute a violation of the rules and/or statutes which the state has alleged in the notice of hearing. You must make findings of fact based solely upon the evidence presented before you in this hearing. The notice of charges filed by the state is not evidence, and the notice of charges may be used as a guide to assist you in making your findings, but it is the sole responsibility of the board to make your own findings of fact in this matter. You should use the proposed orders applied by the state only after careful consideration and determination that the notice or the proposed findings of fact conclusions of law in the proposed order accurately reflect your own independent recollection of the evidence and your own conclusions. Specifically in this matter, the state alleges that the respondent has violated parts of Tennessee Code annotated 62-32-304 and the rules of the Board of Alarm Contractors, Rule 0090-01-.04 and 0090-01, 0.07, 1 and 3. The state has the burden of proof in this case. It is the state's burden to establish all the facts necessary to prove each and every violation which has been alleged. The respondent does not have the burden of proving that it is innocent of the charges. A preponderance of the evidence means that amount of evidence that causes you to conclude that an allegation is probably true. To prove an allegation by the preponderance of the evidence, a party must convince you that that allegation is more likely true than not true. If the evidence on a particular issue is equally balanced, that issue has not been proven by a preponderance of the evidence, and the party having the burden of proof in that matter has failed on that issue. You must limit your inquiry in this matter regarding to violations of statutes and rules which have been alleged in the state's notice of charges. For instance, if you believe that the respondent has violated some other statute or rule which has not been alleged as violated in the notice of charges, you may not inquire into or address violations not set forth in the notice of charges. Members of the board, you are the sole and exclusive judges of the credibility or the believability of the witnesses who have testified in this matter. You must decide which witnesses you believe and how important you believe their testimony is. You are to decide this case only from the evidence which was presented at the hearing. The evidence consists of sworn testimony of the witnesses who have testified, the exhibits which were marked and entered into evidence, any facts which the parties may have agreed or stipulated to. In making your decision, you must consider the evidence in light of your own reason, training, experience, and common sense. You cannot base your findings on speculation, guesswork, or conjecture. You must not infer from any of my rulings or any of my instructions that I hold any view or opinion for or against any party in this matter. None of my remarks have been intended to indicate an opinion regarding the facts or what your decision should be. The Administrative Procedures Act, TCA Section 4-5-101 at SEC, specifically requires the board's order in this matter to contain findings of fact, conclusions of law, and the policy reasons for your decisions. If the board decides that a violation or violations of state rules and/or statutes have occurred, the board must then decide what discipline or action by the board, if any, is appropriate. The board may, when it deems it appropriate, assess civil penalties. In this case, the state is requesting that the board assess civil penalties against the respondent pursuant to TCA Section 62-32-320. If the board finds that the state has proved by preponderance of the evidence that the respondent has committed the violations of operating without certification as required by state law, the board may assess a civil penalty of no more than $1,000 and no more than $5,000 per occurrence. No less than $1,000, and no more than $5,000 per occurrence. The board may also declare contractors who have violated the state certification requirement ineligible to apply for certification for up to 6 months following the determination that such violations have occurred. Pursuant to Rule 0090-2-.01 and Tennessee Code Annotated 62-32-320, in determining the amount of any penalty which the board may decide to assess, the board shall consider the degree and extent of harm caused by the violation. Members of the board, you may consider any discipline or any evidence that the parties have introduced on the issue of appropriate disciplinary action, including whether or not the conduct was or is of a continuing nature or whether it was a one-time offense. Any motions to adopt findings of fact, to find that the respondent has or has not committed violations of a statute or rule, motions to formulate discipline, if any, and the policy reason which the board may formulate, and must formulate actually, must be carried by a simple majority of the board. The policy reason is required for your order by the Administrative Procedures Act. With regard to the board's stated policy decision for the action, the policy reason generally states why your decision in this situation is appropriate. Just as way of example, some boards refer to their rules stated purpose in assisting the board to craft their policy statement. Unless there are other questions about my charge, I'll now turn the hearing over to Captain Gibson, the chairperson, to preside over the deliberations in this matter.
Take a couple minutes to read through the proposed findings.
Y'all take as long as y'all want to read, and just let us know when you're ready to resume deliberations.
No, there's some more. Yeah.
We got to do the policy first, right? The policy's got to find it. And policy.
We can recess for a minute if you need to.
I don't know if this needs report.
Oh,
Somebody in the band who was getting them up.
Yep.
Has everyone had an opportunity to review all of the documents?
Yes.
Are we ready for discussion, Jefferson?
Yes.
Mr. Roberts, do you go?
Madam Chairman, I would make a motion that these be our findings of fact. First, at all times pertinent here to through the present, the respondent has never certified, has never been certified by the board as an alarm systems contractor pursuant to Tennessee Code Annotated Title 62, Chapter 32, Part 3, enabling it to lawfully sell, attempt to sell, install, or service or monitor alarm systems in Tennessee. Further, the respondent has never, through April the 2nd, 2012, submitted any application to become certified as an alarm systems contractor in Tennessee. Secondly, as of April 2nd, 2012, according to the filing statement by the respondent, which was Exhibit 6 as presented, the respondent is a for-profit corporation incorporated in Washington, in the state of Washington. The respondent's listed business address on this application is 8525 120th Avenue Northeast, Kirtland, Washington, with a zip code of 98033. Item 3. Respondent indicates on its website, that is www.ulcenter2.shoppingcartforus.com, printed by the state on April the 2nd, 2012, that it offers a listed monitoring for intrusion, fire, panic, duress, hold-up, medical, and etc. for commercial, industrial, and residential locations. Fourthly, on its website, printed on both March 14th, 2011, and again on April the 2nd, 2012, the respondent holds itself out as engaging in the practice of alarm systems contractor in Tennessee and offers alarm monitoring in all 50 states, that is, nationwide. Respondent's website references a state licensing number in Tennessee of NA 3600328, and further notes that the NA reference on the website claims either that its licensing was in process in Tennessee or that licensing is not required. Both of these assertions, as contained on the respondent's website, are false. Because certification to act as an alarm systems contractor in Tennessee is and has been required since 1992. And we really didn't start it until 92. And until July 12, 2012, the respondent has never had any application for certification in process with this board as of those dates. Further, no applicant for license or certificate from this board can assume that the board will grant the application. Fifth, at some point in 2001, respondent contacted complainant Ronnie Pollard, owner and DQA of Mid-South Security and the Intercoms of Olive Branch, Mississippi, a duly certified alarm systems contractor in Tennessee, offering alarm monitoring services, and representing to the complainant that the respondent was certified to do alarm contracting work in Tennessee. 6. In or about November 2001, based on the aforementioned representations that the respondent set forth, and with the understanding that the respondent was licensed in Tennessee, complainant Pollard, on behalf of this company, Mid-South Security and Intercoms, here and after Mid-South, entered into an oral agreement with the respondent, whereby a respondent began providing alarm monitoring services for the complainant's clients. Complainant Pollard has client accounts in Shelby County, Tennessee, and North Mississippi areas. The respondent and Mid-South continued to operate under this oral agreement until February 2010. 7. On or about February 12, 2010, complainant Pollard entered into a written wholesale monitoring services agreement on behalf of Mid-South as prepared by the respondent. Mid-South in that contract is referred to as the dealer in that written monitoring agreement, and the respondent is referred to as ADM. With respect to the question of licensing, numbered paragraph 39 of this written agreement prepared by the respondent includes the following language. This numbered paragraph 39 says, dealer agrees that in the event out-of-state monitoring of dealer accounts by ADM requires specialized licensing in the state or local licensing, dealer agrees to assist ADM in obtaining said licenses, to which agrees to pay for all fees related to said licensing, unless 500 or more accounts are within said area of the licensing jurisdiction. Number 8. Upon discovery in July of 2010, the respondent was not certified by this board to provide alarm monitoring services within the state of Tennessee. The complainant ceased and desist from all further involvement with the respondent insofar as monitoring services are concerned, and entered into a new contract with the Tennessee Certified Alarm Contractor that provides its monitoring services with the complainant's account in the state of Tennessee and North Mississippi. 9. At the time of the complainant's discovery in July of 2010, the respondent's lack of Tennessee certification and complainant's cessation of further business relations with the respondent, approximately 150 of the complainant's 425 accounts, client accounts, were being monitored by the respondent in Tennessee. 10. On September 10, 2010, the respondent filed a lawsuit in the Superior Court of Washington for King County against the complainant, the complainant's wife, in Mid-South, alleging breach of contract and seeking $217,052.99 in damages plus costs and attorney's fees. 11. On or about November the 12th, 2010, respondent through counsel presented complainant with proposed general release and settlement agreement regarding then pending lawsuit, which requested that the complainant, that is the defendant, again assist the respondent, that would be the plaintiff, in the unauthorized practice as an alarm systems contractor in Tennessee. Specifically, this November 2010 release and the settlement proposal prepared by the respondent insisted that the complainant restore, as of February 1st, 2011, a minimum of 425 subscriber accounts, which shall begin being monitored by the plaintiff, as the contract plainly states. Moreover, this settlement proposal recited that the plaintiff shall make a good faith effort and defendant will assist in obtaining a Tennessee license for third-party monitoring prior to February 1st, 2011. However, a failure to not obtain said license shall not prevent provisions within the settlement agreement from being enforced. 12. Through April 2nd, 2012, the respondent has not made any good faith attempt to become certified as an alarm systems contractor by this board, as it's stated in its settlement proposal submitted to the complainant on November 2010. 13. In late January of 2011, the respondent was served by certified mail with a copy of the notice letter from the board staff enclosing the complaint made by Mr. Pollard alleging unlicensed conduct in this matter. The respondent has refused to answer the complaint or to attempt to explain its actions to the board staff prior to the filing of the notice of hearing and charges herein. 14. The state filed its notice of hearing and charges in this matter on April the 3rd, 2012. The respondent was served with a copy of the April 3rd, 2012 notice of hearing and charges in this matter on April 9th, 2012 by certified return receipt certified mail return receipt requested. 15. The respondent delivered in its first application seeking to become a certified in Tennessee as alarm systems contractor to the board staff on July the 12th of 2012. 16. On its website printed by the state on October the 2nd, 2012, the respondent continues to hold itself out as engaging in the practice of alarm systems contractor in Tennessee by referencing a state licensing number in Tennessee of NA 3600328, where the NA reference on the website claims either that its licensing was in process in Tennessee or the licensing was not required. 17. Respondent has not been informed by board staff that a license or certificate as alarm systems contractor was in process for the respondent merely because the respondent submitted an application for a certificate in July of 2012. Madam Chairman, I would propose those as our findings of fact. Second.
Okay. We have a motion and a second to adopt findings of fact as read into the record by Mr. Roberts. All in favor, voice by saying aye.
Aye.
Any opposed? Motion carries. Next, we move into the laws and conclusions of laws and orders.
Madam Chairman, I would make a motion that we adopt the following proposed conclusions of law. First, Respondents' Act of Conduct and Monitoring Tennessee Alarm Systems is set out in numbered paragraphs 5 through 9. The foregoing findings of fact establish that the respondent is engaged in the business of alarm systems contractors defined by Tennessee Code annotated 6232-303, subparagraph 2, the relevant portion of which reads as follows. 6232-303, part definitions, subparagraph 2 states the alarm systems contractor means any person, firm, association, or corporation that sells or attempts to sell, installs, services, or monitors alarm system signal devices, fire alarms, burglar alarms, television cameras, or still cameras are used to detect burglary, breaking or entering, intrusion, shoplifting, pilferage, or theft. Breaking, let me find it here. Breaking or entering, intrusion, shoplifting, pilferage, or theft. Number 2, Respondents' Act and Conduct in holding itself out on its website as alarm systems contractor in Tennessee, in monitoring Tennessee alarm systems for several years since 2001, and in attempting to continue an act as an alarm systems contractor after filing suit against the complainant herein, all is set out in numbered paragraphs 2 through 11 of the foregoing findings of fact constitute violation of Tennessee Code annotated 6232-304, subparagraphs A and J, the relevant portions of which read as follows. 6232-304, which indicates prohibiting activities, requirements. Subparagraph A indicates that no person shall engage in or hold out as engaging in the business of alarm systems contractor without first being certified in accordance with this part. Subparagraph J indicates that no person shall sell and install, service, monitor, or respond to alarm signals and signal devices, fire alarms, burglar alarms, television, or still cameras used to detect fire, burglary, breaking or entering, intrusion, shoplifting, pilferage, or theft in violation of this part or the rules adopted under this part. Number 3, respondents act in conduct in failing to complete and submit an application for certification to this board on board prescribed forms until July the 12th, 2012 by falsely advertising on its website that Tennessee licensing was in process, and by failing to make good faith effort to obtain a Tennessee alarm systems contractor certification as set out in numbered paragraphs 1, 4, 11 through 12, 11 and 12, and 15 through 17 of the foregoing findings of fact. Those constitute violation of Tennessee Code annotated Tennessee Comprehensive Regulations 0090-01-.04 and 0090-01-.07 subparagraph 1 and subparagraph 3. Relevant portions of which read as follows. Regulation 0090-01-04 is entitled Application for Certification, License, or Registration. States that all companies or persons who seek to be certified, licensed, or registered must complete an application on forms prescribed by the board and submit the completed application forms to the board. Rule number 0090-01-.07, which is entitled Alarm Systems Contractor Requirements, subparagraph 1 states that any person desiring to be certified as alarm systems contractor shall make the written application to the board on such forms as are prescribed by the board. Subparagraph 3 states that the applicant for an alarm systems contractor shall apply for each classification in which it will be engaging in alarm systems contracting activity. Number 4. Respondents' violations of Tennessee Code annotated 6232-304 subparagraphs A and J constitute grounds for the imposition of civil penalties not less than $1,000 or more than $5,000 per each occurrence of such unlicensed activity, conduct pursuant to Tennessee Code annotated 6232-320 subparagraph B, Tennessee Comprehensive Rules and Regulations 0090-2-.01 subparagraph 1, which is entitled Civil Penalties. Number 5, respondents' violations of the board's rules found in the Tennessee Comprehensive Rules and Regulations 0090-01-.04 and 0090-01-.07 subparagraph 1 and 3 subparagraph 3 constitute grounds for the imposition of civil penalties of not more than $5,000 per each of separate violations of the board rules pursuant to Tennessee Code annotated 6232-320 subparagraph C, the Tennessee Comprehensive Rules and Regulations 0090-2-.01 subparagraph 4, which is entitled Civil Penalties. Madam Chairman, I would propose that those be our conclusions of law. Yes.
We have a motion and a second to accept as our conclusions of the rules and laws what Mr. Roberts has read into the record. All in favor, voice by saying aye.
Aye.
All opposed, motion carries. Next, we move into the civil penalty, which Mr. Joseph, on paragraph C, should that month in line 3 be possibly a year? Is that your intention?
$100 per month. It was per month.
Yes, sir, but we don't. We're over the 10 and 1/2.
Year, that's correct, that's a typo.
Just wanted to make sure.
There's
Mr.
another
Raleigh,
typo as
were you
well.
clear on that change?
There's another typo as
Whereas for C.
well. Well, at the very bottom, it says the month,
Oh,
in item C, the month respondent's application was approved. It hasn't been approved, that should have been submitted.
okay. Has the board had an opportunity to review the proposed civil penalties from the state? And if so, we're open for discussion. Okay. Does the board have an issue with the language found in paragraph A? Sure. Just read it out.
Madam Chairman, I would make a motion that our proposed judgment and penalty be as follows. And they would be that the respondent is assessed $135,800 in civil penalties for which execution shall issue if necessary as follows. One, $103,000 for its unlicensed conduct in violation of Tennessee Code annotated 6232-304 subparagraph J, which is monitoring the complainant's client accounts for over 8.5 years between 2001 and July of 2010 without having a warrant contractor certificate issued by the board. And that's calculated at the rate of $1,000 per month and treating each month of unlicensed conduct as separate violations. It would be $1,000 per month for 103 months. And I would note that that is the minimum dollar figure per occurrence provided for in our statute. Secondly, $20,000 for holding itself out on its website as engaging in business alarm systems contractor in Tennessee in violation of Tennessee Code annotated 6232-304 subparagraph A between March 2011, which was the first month the state obtained a copy of its website, and October 2012, the last month the state obtained a copy of its website, which were presented as exhibits, calculated at the rate of $1,000 per month and treating each month of such conduct as a separate violation. That's $1,000 per month for 20 months. And I would note that these months are the ones that have been validated through testimony. 3, $12,800 for failing to submit an application for certification of this board as required by Tennessee Comprehensive Rules and Regulations 0090-01-04 and 0090-01-.07 subparagraphs 1 and 3. And that's calculated at the rate of $100 per month for the over 10.5 year period of the time from November 2001 through July 2012, which is the months that the respondent's application was submitted, treating each month of the conduct as a separate violation at $100 per month for 128 months. Now, I would also add to our proposed judgment that the respondent be assessed all investigatory and hearing costs incurred by the state herein pursuant to Tennessee Code annotated 56-1-311 subparagraph A, and Tennessee Comprehensive Rules and Regulations 0780-5-11-.01, which is entitled The Assessment of Investigatory Hearing Cost, for which the execution shall issue if necessary. Madam Chairman, I would propose that that be our judgment from Tennessee.
We have a motion by Mr. Roberts regarding the civil penalties as read into the record.
Second.
We have a motion and a second in this matter. All in favor, please say aye.
Aye.
Any opposed? Motion carries. Regarding the policy statement, I can throw this out if there's anything that I've left out that I feel needs to be included. From 2001 until 2012, said company operated in Tennessee as a monitoring company without ever having made an application until July 2012. Even after the state sent a registered notification to the company regarding the complaint, which was sent in January of 2011, said company continued to list on their website that they were either licensed or undergoing licensing, or license not required, or in the process of being licensed in the state of Tennessee. The website is also unclear to the general public that this is strictly a dealer's website. From the period of January 19, 2011 until July of 2012, no action was taken by this company to correct their violations of Tennessee state laws, rules, and policies. The reason that these were put into place are to protect the citizens of Tennessee, in which approximately 150 to 200 homes did receive monitoring service in Tennessee.
The first date you mentioned there was 2011. Was that?
2001 is when we first had them.
2001 until
2012. They made application in July of 2012. The state notified them in January of 2011 of the complaint about unlicensed activity. They took no action to correct this or respond to the complaint until July 2012. Although they maintained their illegal advertisement on their website.
I think I misunderstood the dates.
You may have, because I was searching hard to make sure I'm all correct. Is there anything else we want to repeat?
I second.
Oh, go.
Make a motion that what she has read into
The record.
is read into the record, the policies.
I second.
We have a motion and a second. All in favor, voice will say aye.
Aye.
Any opposed? Motion carries.
Anything further, council? All right, we'll stand adjourned. Thank you all very much.
Thank you.